Every year, 2 million tourists walk Savannah's cobblestone streets, photograph its moss-draped squares, and pay for ghost tours through Colonial Park Cemetery. They see beauty. They don't see what happened in 2006, when a 28-year-old from one of the city's founding families was found dead in the marshes beyond Tybee Island. Her body wrapped in a Confederate flag quilt that DNA analysis would later trace to a mansion on Jones Street, one of the most expensive addresses in Georgia. The killer had connections. The investigation stalled. Witnesses who'd seen something forgot what they knew. Evidence mysteriously degraded in storage. For 18 years, the case was Savannah's open secret, whispered about in junior league meetings and yacht club gatherings but never spoken aloud. Then in 2024, a forensic genealogist in California uploaded crime scene DNA to GEDmatch and traced it to a family whose name appears in textbooks about colonial Georgia. The arrest warrant named someone nobody expected. Someone whose wife had served as president of the Garden Club, whose children attended Savannah Country Day School, whose great-great-grandfather signed the city charter. In Savannah, where image is everything and old families never fall, this case didn't just solve a murder, it shattered the illusion that wealth, pedigree, and southern gentility could keep darkness at bay forever. The last photograph of Caroline Ashford Whitmore alive was taken at the opening reception of the Telfair Academy's spring exhibition on the evening of April 14, 2006. She stood near a chilled Hassam painting, a champagne flute in her hand, her honey blonde hair swept into the kind of effortless updo that only women from certain families seem to master. She wore a pale blue silk dress that her grandmother had worn to a debutante ball in 1952, altered slightly at the waist but otherwise preserved perfectly, like so many things in Savannah. In the photograph, she was laughing at something someone had said, her head tilted back, completely unaware that in less than 6 hours she would be dead. Caroline was 28 years old, a curator at the Jepson Center for the Arts, and the youngest daughter of one of Savannah's most prominent families. The Whitmores had lived in the city since 1740, just 7 years after James Oglethorpe founded the colony. Their name appeared on historical markers, on wings of hospitals, on endowed chairs at the Savannah College of Art and Design. Caroline's father, Richard Whitmore III, served on the board of the historic Savannah Foundation. Her mother, Margaret Beaufort Whitmore, was a direct descendant of one of Georgia's colonial governors. In Savannah's carefully maintained social hierarchy, the Whitmores were what people called Old Savannah, which meant something quite specific in a city obsessed with lineage and propriety. The exhibition opening that April evening was a typical Savannah affair, the kind of event where attendance was both a social obligation and a performance of cultural sophistication. Approximately 200 guests moved through the gallery's white-walled spaces, their conversations a practiced blend of art criticism and social gossip. Caroline had curated the exhibition herself, a collection of low-country landscapes spanning 2 centuries, and colleagues remembered her being animated that evening, pleased with how the installation had turned out, grateful for the turnout, despite the humid weather that had threatened rain all week. The reception officially ended at 9 p.m., though clusters of guests lingered until nearly 10, finishing wine and exchanging the kind of drawn-out southern goodbyes that can take 20 minutes of standing at the door. Caroline stayed until the last guest departed, helping the catering staff collect glasses and making notes about pieces that had generated particular interest. Security footage from the Jepson Center showed her leaving through the staff entrance at 10:37 p.m., pulling her cardigan tight against the spring chill that descends on Savannah once the sun sets. She walked to her car, a cream-colored 1994 Mercedes sedan that had belonged to her grandfather, parked in the small lot behind the museum. What the security camera captured next would become the subject of endless analysis by investigators and later, by armchair detectives on true crime forums. At 10:39 p.m., a dark-colored pickup truck pulled into the parking lot and stopped near Caroline's Mercedes. The footage was grainy, the lighting poor, but it appeared that someone got out of the truck and approached Caroline as she was unlocking her car door. They seemed to speak for approximately 2 minutes. Then Caroline got into her Mercedes, the pickup truck backed out of the lot, and both vehicles drove away. The sequence looked entirely ordinary, a brief conversation between acquaintances, nothing that suggested danger or distress. Caroline's Mercedes was found 38 hours later, abandoned in a public parking area near Tybee Island, the barrier island 20 miles east of downtown Savannah, where locals and tourists alike go for beach access. The car was parked legally, locked with no signs of disturbance inside. Her purse sat on the passenger seat, wallet intact with cash and credit cards. Her cell phone was in the center console, battery dead. The only unusual detail was that the driver's seat was pushed back farther than Caroline's petite frame would have required, suggesting someone taller had driven the car to that location. The Savannah-Chatham Metropolitan Police Department responded to the Whitmore family's missing person report on the morning of April 16 with the kind of immediate attention that cases involving prominent families typically receive. Detective Marcus Faulkner, a 20-year veteran of the force, was assigned as lead investigator. He was a Savannah native himself, which in that city meant he understood the complex web of relationships and reputations that govern social interactions. He knew the Whitmores by reputation, had seen Richard Whitmore III at various civic functions, understood that this case would have visibility far beyond a typical missing person investigation. Faulkner's initial approach was methodical. He interviewed the museum staff who'd been present at the reception, asking about Caroline's demeanor, whether she'd mentioned plans for after the event, whether anyone had seemed to pay unusual attention to her. Everyone described her as happy, professional, excited about the exhibition's success. No one reported anything suspicious. He obtained the security footage from the Jepson Center and spent hours reviewing it, frame by frame, trying to identify the pickup truck and its driver. The vehicle's license plate wasn't visible in the footage, and the make and model were difficult to determine, given the poor image quality and the angle of the camera. The discovery of Caroline's body came on April 19, 5 days after she disappeared, when two men kayaking through the marshes beyond Tybee Island's south end noticed what they initially thought was debris caught in the spartina grass. As they paddled closer, the shape resolved into something that made one of them vomit into the brackish water and the other fumble for his cell phone with shaking hands. Caroline's remains were partially submerged in a tidal creek, wrapped in what appeared to be an old quilt, the fabric waterlogged and heavy with mud and decomposition. The crime scene was a nightmare for forensic processing. The marshes beyond Tybee are a complex ecosystem of mud flats, tidal creeks and salt grass that flood twice daily with the tides. Whatever evidence might have existed on Caroline's body or the quilt wrapping had been subjected to 5 days of tidal washing, exposure to salt water, and the attention of crabs and other marine scavengers. The Georgia Bureau of Investigation's crime scene unit worked in waders and protective gear, documenting everything they could before carefully extracting the remains from the marsh and transporting them to the GBI crime lab in Savannah for autopsy. Dr. Patricia Hammond, the forensic pathologist who performed the autopsy, found that Caroline had died from manual strangulation, the hyoid bone in her throat fractured and significant petechial hemorrhaging visible in her eyes despite the decomposition. There was evidence of sexual assault, though the extended time in water had compromised much of the physical evidence. What DNA was recovered came primarily from under Caroline's fingernails, where skin cells indicated she'd scratched her attacker, and from the quilt itself, where multiple touch DNA samples were collected from areas that had been protected from water damage by the way the fabric was folded. The quilt was significant. It was an antique hand-stitched, featuring a pattern common in the mid-19th century. But most notably, it incorporated sections of what appeared to be Confederate flag fabric, the kind of heirloom that old Southern families sometimes preserved as historical artifacts, regardless of the increasingly complicated symbolism such items carried. Textile experts from the Savannah History Museum examined it and determined it had been made sometime between 1860 and 1880, likely in Georgia or South Carolina, based on the stitching patterns and fabric types. This wasn't something you'd find in a thrift store or buy online. This was a family heirloom, the kind of object that would have been passed down through generations, stored in a cedar chest or displayed in a formal parlor. Detective Faulkner focused his initial investigation on Caroline's personal life, following the standard investigative protocol that looks first at intimate partners, then family, then acquaintances. Caroline had dated casually, but had no serious boyfriend at the time of her death. Her ex-boyfriend from college, a lawyer now practicing in Atlanta, had an airtight alibi, having been in court in Fulton County the entire week Caroline disappeared. Her friends described her as private but happy, dedicated to her work, close with her family, active in the Junior League and the Preservation Society. There were no obvious enemies, no financial problems, no secret life that might explain her murder. The investigation's focus then shifted to the security footage from the Jepson Center and the unidentified pickup truck. Faulkner obtained footage from traffic cameras and nearby businesses, trying to track the truck's movements after it left the museum parking lot. The trail went cold within a few blocks. The vehicle had either turned into a residential neighborhood without traffic cameras or the driver had deliberately taken a route that avoided main thoroughfares. A detailed analysis of the footage suggested the truck was likely a late 1990s or early 2000s Chevrolet or GMC, dark blue or black, but without a visible license plate, and given the image quality, that description fit thousands of vehicles in Chatham County. The DNA evidence collected from under Caroline's fingernails and from the quilt was processed by the GBI Crime Lab and entered into CODIS, the combined DNA index system that links federal, state, and local databases of DNA profiles from convicted offenders and unsolved crimes. In 2006, CODIS was already an established tool in criminal investigations, but its effectiveness depended entirely on whether the perpetrator's DNA was already in the system. The results came back after several weeks: no matches. Whoever had killed Caroline Whitmore had either never been convicted of a crime requiring DNA collection, or had committed this murder before his DNA entered the system. Faulkner expanded his investigation to include anyone who might have had access to a quilt, matching the description of the one used to wrap Caroline's body. He interviewed antique dealers, historical society members, and families known to possess Confederate-era artifacts. This approach was delicate, given Savannah's complicated relationship with its Confederate past and the fact that many prominent families had such items tucked away in attics or storage. The responses ranged from helpful to defensive to outright hostile, with several families refusing to discuss their private collections with police, citing concerns about theft or unwanted publicity. One promising lead emerged when a woman named Elizabeth Coldwell, a docent at the Green Meldrum House Museum, mentioned that she'd seen a similar quilt years ago at a private estate sale held at a mansion on Jones Street. She couldn't remember the exact address or the family name, but she recalled being struck by the craftsmanship of the textile and troubled by the Confederate imagery. Faulkner followed up, obtaining records of estate sales in the Jones Street area between 2000 and 2006, but the paper trail was incomplete. Many high-end estate sales in Savannah were conducted privately, by invitation only, to protect family privacy and maintain discretion about financial situations. Jones Street itself is one of Savannah's most prestigious addresses, a single block running between Bull Street and Drayton Street, lined with antebellum townhouses and covered by a canopy of live oak trees so dense that the Spanish moss nearly touches the brick pavement. The street had once been described by Lady Astor as the most beautiful street in America, and property values reflected that reputation. The families who lived there were overwhelmingly old Savannah, with genealogies that traced back to colonial times and social connections that formed an impenetrable web of mutual protection and discretion. As the investigation stretched into summer 2006, media coverage intensified. The murder of a young woman from a prominent family, particularly one as brutal and mysterious as Caroline's, was the kind of story that captured public attention. Local television stations ran nightly updates. The Savannah Morning News published front-page stories detailing the investigation's progress, or more accurately, its lack thereof. The national media picked up the story as well, drawn by the elements that made it cinematically compelling: the beautiful young curator, the historic southern city, the antique quilt with Confederate symbolism, the wealthy family demanding answers. This publicity created both opportunities and problems for the investigation. Tips flooded in, most of them useless, some actively misleading. People reported seeing Caroline alive days after her body was found, others claimed to know who the killer was, offering theories that ranged from plausible to paranoid. A few tips seemed promising, including one from a Tybee Island resident, who claimed to have seen a dark pickup truck parked near the Marsh Access Road on the night of April 14. But when Faulkner followed up, the witness couldn't provide specific details about time, license plate, or distinguishing features. The Whitmore family, meanwhile, navigated their grief under intense public scrutiny. Richard Whitmore III made several public appeals for information, standing at press conference podiums with his wife and 2 other daughters, his voice breaking as he described Caroline's love for art and history, his desperation for justice. Margaret Whitmore appeared less frequently, her grief seemingly too overwhelming for public display. Though she was photographed at Caroline's funeral, looking pale and hollow-eyed, supported by her daughters as they walked behind the casket into Christ Church Episcopal, where Whitmores had been baptized, married, and buried for 7 generations. The funeral itself was a testament to the family's standing in Savannah. The church was filled beyond capacity, with mourners standing in the aisles and spilling out onto Johnson Square. The eulogies emphasized Caroline's intelligence, her dedication to preserving Savannah's cultural heritage, her kindness. The bishop presiding over the service invoked themes of justice and divine mercy, suggesting that while earthly justice might be slow, ultimate justice was certain. Caroline was buried in Bonaventure Cemetery, the sprawling Victorian burial ground overlooking the Wilmington River that tourists visit to photograph its moss-draped statuary and winding paths. Her grave marker, a simple marble stone engraved with her name, dates, and a line from Keats, became a site where people left flowers and notes long after the initial wave of grief had passed. As summer turned to fall, the investigation began to lose momentum. Faulkner had conducted over 300 interviews, obtained dozens of search warrants, and followed every lead that seemed even remotely credible. But without a DNA match, without a viable suspect, without witnesses who could identify the driver of the pickup truck, the case was stalling. The GBI brought in additional resources, including behavioral analysts from the FBI's Violent Criminal Apprehension Program, who developed a profile of the likely offender, male, probably white given the demographics of Savannah's wealthy neighborhoods, aged 30 to 50, with local connections and knowledge of the marshes, possibly someone with a personal connection to the Whitmore family, or to Caroline herself. The profile suggested the killer was organized, capable of planning and executing the crime, with enough sophistication to avoid immediate detection. The use of the quilt was particularly significant, psychologically. It suggested either an attempt to show respect for the victim by wrapping her before disposal, or alternatively, a symbolic gesture meant to communicate something about Southern heritage, family legacy, or racial identity. The behavioral analysts noted that killers who went to the trouble of wrapping victims' bodies often had personal connections to them, distinguishing this from stranger murders where bodies were typically discarded without such care. By winter 2006, the Savannah-Chatham Metropolitan Police Department officially classified the case as cold, though Faulkner refused to abandon it entirely. He kept the file on his desk, reviewing it during slow periods, convinced that the answer was somewhere in the evidence they'd already collected, in the interviews they'd already conducted, in the web of connections between Caroline and her killer. He developed a theory, one he couldn't prove but couldn't shake. The killer was someone Caroline knew, possibly someone from her social circle, someone who had access to the kind of Confederate-era quilt found with her body. That narrowed the suspect pool considerably, but without DNA to compare or witnesses willing to speak, the theory remained just that. The years that followed were difficult for everyone connected to the case. The Whitmore family established a memorial fund in Caroline's name, providing scholarships for art history students at SCAD. They held annual memorial services at Christ Church, gatherings that grew smaller each year, as the initial shock faded and people moved on to other tragedies, other causes. Richard Whitmore became active in victims' rights advocacy, speaking at conferences and lobbying for increased funding for cold case investigations. Margaret Whitmore largely withdrew from public life, resigning from her various board positions and social committees, seen only occasionally at church or walking alone through Colonial Park Cemetery. Detective Faulkner retired in 2014, 8 years after Caroline's murder, still haunted by the unsolved case. At his retirement party, held at a restaurant on River Street with views of the Savannah River and the cargo ships passing by, he told colleagues that the Whitmore case was the one that would stay with him forever, the one that proved that sometimes knowing who did it isn't enough if you can't prove it. He never explicitly named his suspect, bound by the ethical constraints of investigation and the legal dangers of defamation, but those who worked closely with him understood that he'd developed a theory about a specific individual, someone with means and connections, someone who'd been interviewed early in the investigation and never interviewed again. The case remained cold for 18 years. During that time, Savannah continued to evolve while somehow staying exactly the same. The city's tourism industry grew exponentially, with historic district walking tours and ghost tours becoming major economic drivers. The Jepson Center, where Caroline had curated her final exhibition, continued to present shows that drew visitors from around the world. Jones Street remained one of the most expensive residential addresses in Georgia, with antebellum townhouses selling for millions of dollars to buyers drawn by the prestige of the location. And through it all, the murder of Caroline Whitmore became one of Savannah's dark legends, mentioned on certain ghost tours, whispered about in certain circles, but gradually fading from active memory like so many old secrets in a city built on discretion. The break in the case came not from new witnesses or traditional detective work, but from technology that didn't exist in 2006. In early 2024, the GBI's Cold Case Unit, established in 2019 to re-examine unsolved homicides using modern forensic techniques, selected the Whitmore case for review. Special Agent Jennifer Ramos, a forensic genealogist who'd trained in California with the same team that had solved the Golden State Killer case, requested the DNA evidence that had been carefully preserved in the GBI Crime Lab's freezers for 18 years. The DNA extracted from under Caroline's fingernails and from the quilt had been stored properly, maintained at -80°C to prevent degradation. This was fortunate, as not all evidence from 2006 had been preserved with the same care. Ramos worked with Othram Labs, a private forensic laboratory in Texas that specialized in forensic-grade genome sequencing, to build a comprehensive DNA profile from the samples. Unlike the STR short tandem repeat analysis used in standard CADIS testing, which examines only 13 to 20 specific markers, forensic genome sequencing analyzes hundreds of thousands of markers across the entire genome, providing enough data to search genealogical databases. The process took 3 months and cost approximately $15,000, funded by a grant from a non-profit organization dedicated to solving cold cases involving violence against women. By May 2024, Othram had built a comprehensive SNP, single nucleotide polymorphism profile from the DNA evidence. Ramos uploaded this profile to GEDmatch, a public genealogy database, where users voluntarily upload their DNA data from consumer testing companies like 23andMe and Ancestry.com and Family Tree DNA, which offers similar services. Both databases allowed law enforcement to search for genetic relatives of unknown subjects, though with certain restrictions and privacy protocols. The initial results were promising. The DNA profile matched with several GEDmatch users at the third and fourth cousin level, indicating shared ancestry approximately 4 to 6 generations back. Ramos built family trees for each match, working backward from the known individuals to identify common ancestors. This is where investigative genetic genealogy becomes part science and part historical detective work, requiring access to census records, birth certificates, marriage licenses, obituaries, and other public documents that track family lineages across centuries. What emerged from this genealogical research was a family tree that traced back to colonial Georgia, specifically to one of the original families that had settled in Savannah in the mid-18th century. The tree branched extensively, as families do over 250 years, but all paths led to a cluster of surnames that appeared repeatedly in Savannah's historical records: Mercer, Habersham, Telfair, and Prescott. These weren't just any names, these were the names on street signs, on museums, on historical markers throughout the city. They represented old wealth, old influence, the kind of families that had shaped Savannah's development and maintained social dominance across generations. Ramos narrowed the suspect pool by focusing on male descendants in the appropriate age range, who would have been between 30 and 55 years old in 2006, per the original FBI profile. She cross-referenced these individuals with vehicle registrations from 2006, looking for anyone who owned or had access to a dark-colored pickup truck. She examined property records, looking for connections to Jones Street, or to estates that might have contained Confederate-era quilts. She reviewed the original investigative files, seeing which names in her genealogical research had already appeared in Faulkner's interviews and witness statements. One name appeared repeatedly across all these data points: William Habersham Prescott IV. In 2006, he'd been 42 years old, a partner in his family's commercial real estate firm that managed some of Savannah's most valuable historic properties. He lived in a mansion on Jones Street that had been in the Prescott family since 1842, a 6,000-square-foot Greek Revival townhouse with original heart pine floors, period moldings, and a provenance that included housing union officers during Sherman's occupation of Savannah. He drove a 2003 Chevrolet Silverado, black, registered in his name, and according to estate inventory records obtained through Historical Society archives, the Prescott family collection included numerous Confederate-era artifacts, textiles, and memorabilia. Most significantly, Prescott had been interviewed briefly during the original 2006 investigation. He'd attended the exhibition opening at the Jepson Center on the night Caroline disappeared, as had approximately 75 other people. Detective Faulkner's notes from that interview, conducted 3 days after Caroline's body was found, indicated that Prescott claimed to have left the reception around 8:30 p.m., driven home, and spent the evening with his wife and 2 teenage children. His wife, Amelia Rutledge Prescott, had confirmed this alibi when contacted by phone. Faulkner's notes included no indication that Prescott had been considered a serious suspect or that any follow-up interview had been conducted. Ramos brought her findings to the GBI's Cold Case Unit supervisor and to the Chatham County District Attorney's Office in June 2024. What she presented was circumstantial but compelling: genetic genealogy, placing the unknown DNA within Prescott's family tree, vehicle records consistent with the truck seen on surveillance footage, property records connecting him to the type of quilt used to wrap Caroline's body, and most importantly, the fact that he'd been present at the Jepson Center the night Caroline disappeared. However, circumstantial evidence alone wouldn't support an arrest warrant. They needed direct DNA confirmation. Georgia law allows police to collect abandoned DNA from suspects without a warrant, using items the suspect has voluntarily discarded in public. This technique, sometimes called trash pulls or surreptitious sampling, has been upheld by courts under the reasoning that people have no reasonable expectation of privacy in items they throw away. The GBI decided to pursue this approach with Prescott, conducting surveillance and collecting any items he might discard that could yield DNA for direct comparison with the crime scene evidence. The operation began in early July 2024. GBI agents followed Prescott's movements, documenting his daily routines. He left his Jones Street mansion each morning around 8 a.m., drove to his office on Broughton Street, conducted business that involved meeting with property managers and investors, often lunched at the Old Pink House or the Pirate's House, and typically returned home by 6 p.m. He attended services at Christ Church Episcopal on Sundays, the same church where Caroline's funeral had been held. He played golf at the Savannah Golf Club on Saturday mornings. His life appeared to be one of comfortable routine, the privilege of old money, and established position. On July 18, 2024, Prescott stopped at a Starbucks on Abercorn Street during his morning commute. He ordered his usual coffee, stood at the counter checking his phone while he waited, and when his drink was ready, he took it outside to his truck. He drove to his office, finished the coffee during a meeting, and when he left for lunch, he tossed the empty cup into a public trash receptacle outside his building. GBI agents monitoring the situation retrieved the cup within minutes, using sterile gloves and evidence bags to preserve any DNA that might be present on the drinking lid. The cup was transported immediately to the GBI crime lab in Savannah. Forensic scientists swabbed the drinking lid, extracting epithelial cells from where Prescott's mouth had made contact with the plastic. They built a full DNA profile using the same techniques applied to the crime scene evidence 18 years earlier. The comparison analysis took 72 hours. On July 21, the results came back. The DNA from the Starbucks cup was a definitive match to the DNA found under Caroline Whitmore's fingernails in 2006. The probability of a coincidental match was 1 in 700 billion, effectively certain identification. Armed with this DNA match, along with the circumstantial evidence Ramos had compiled, prosecutors from the Chatham County District Attorney's Office drafted an arrest warrant for William Habersham Prescott IV, charging him with malice murder, felony murder, aggravated assault, and concealing the death of another. Georgia law defines malice murder as the unlawful killing of a human being with malice aforethought, either express or implied. The felony murder charge alleged that Caroline's death occurred during the commission of another felony, specifically aggravated assault and sexual assault. These charges, if proven, carried potential sentences ranging from life imprisonment to death. The decision about whether to seek the death penalty would come later, after Prescott's arrest and initial court appearances. This decision rested with District Attorney Patricia Simmons, a career prosecutor who'd been elected in 2020 on a platform that included aggressive prosecution of violent crimes. Georgia remains a death penalty state, with executions carried out by lethal injection at the Georgia Diagnostic and Classification Prison in Jackson. Since the reinstatement of capital punishment in 1976, Georgia has executed 76 people, and as of 2024 approximately 40 inmates remained on death row. The decision to seek death penalty required considering numerous factors: the heinousness of the crime, the strength of the evidence, the defendant's criminal history, and the wishes of the victim's family. The arrest was planned for the morning of July 25, 2024, deliberately timed for early hours when Prescott would be at home, and likely to be caught off guard. The GBI coordinated with the Savannah Police Department, which provided tactical support given the high-profile nature of the arrest and the potential for media attention. 20 officers participated in the operation, surrounding the mansion on Jones Street, while a smaller team approached the front door with the warrant. Prescott answered the door in a seersucker bathrobe, his gray hair uncombed, looking confused and then alarmed as he saw the assembled law enforcement. When Agent Ramos identified herself and informed him he was under arrest for the murder of Caroline Whitmore, his face went pale and he reached for the doorframe as if needing support. His wife, Amelia, appeared behind him in the foyer, her expression transforming from confusion to horror as she processed what was happening. Their adult children, both home visiting from their respective cities, emerged from upstairs bedrooms, drawn by the commotion, and stood frozen on the grand staircase watching their father being handcuffed. The scene on Jones Street that morning became instant news. Neighbors emerged from their townhouses, tourists on early morning walks stopped to photograph the police vehicles, and within minutes, local media vans began arriving, their satellite dishes raised, reporters doing live shots with the Prescott Mansion's elegant facade as backdrop. For a city that prided itself on discretion, and where scandal was typically handled behind closed doors with lawyers and quiet settlements, the public arrest of one of Savannah's most prominent citizens was unprecedented. Prescott was transported to the Chatham County Detention Center, where he was processed, photographed, and held pending his initial court appearance. The mugshot that would later circulate in media showed a man who looked older than his 60 years, his face drawn, his expression one of shocked disbelief. He exercised his right to remain silent, speaking only to request his attorney, Carlton Wyatt, a criminal defense lawyer from Atlanta, with a reputation for representing wealthy clients in high-stakes cases. The news of Prescott's arrest dominated local and regional media for days. The Savannah Morning News ran a front-page story with the headline, "Arrest in Whitmore Murder Shocks Historic District," accompanied by photographs of Caroline from 2006 and a more recent image of Prescott at a charity gala. Television stations broadcast segments about the case, interviewing legal experts about the strength of genetic genealogy evidence and what the arrest might mean for other cold cases. National media picked up the story as well, drawn by the same elements that had made Caroline's murder compelling in 2006, now amplified by the added dimension of the accused being from one of the South's oldest families. The Whitmore family issued a statement through their attorney, expressing gratitude to the GBI and relief that an arrest had finally been made. Richard Whitmore, now 78 years old and in declining health, told reporters that he'd always believed justice would come, even when years passed without answers. Margaret Whitmore, 76, made no public statement, but was photographed leaving Christ Church after a private prayer service, supported by her daughters, looking both vindicated and exhausted by 18 years of waiting. The community reaction was complex and divided along lines that reflected Savannah's social stratification. Some people expressed satisfaction that Caroline's killer had been caught, regardless of his family name or social position. Others, particularly within the old Savannah establishment, reacted with disbelief and defensiveness, arguing that the charges must be mistaken, that someone like William Prescott simply couldn't have committed such a crime, that there must be an explanation that would exonerate him. This divide played out in country club conversations, at junior league meetings, in the comment sections of news articles, revealing the fault lines beneath Savannah's genteel surface. The preliminary hearing, held in Chatham County Superior Court on August 2, 2024, was standing room only. Judge Rachel Morrison presided, a stern woman known for running an efficient courtroom and showing little patience for theatrics. Prescott appeared in a dark suit, his hands folded on the defense table, his expression carefully neutral. His wife and children sat in the front row behind him, along with other family members whose surnames read like a tour of Savannah's historical markers: Mercer, Habersham, Telfair, Rutledge. Assistant District Attorney James Crawford presented the state's evidence in clinical detail. He began with the crime scene, displaying photographs that made spectators gasp and Prescott's daughter leave the courtroom in tears. He described the DNA evidence, walking through the chain of custody from 2006 to present, explaining how the samples had been preserved, and how modern forensic genealogy had led investigators to Prescott. He presented the surveillance footage from the Jepson Center, grainy but clear enough to show Prescott's truck in the parking lot at the time Caroline left the museum. He referenced the quilt, explaining how historical records indicated the Prescott family possessed Confederate-era textiles consistent with the one used to wrap Caroline's body. Most damning was the direct DNA comparison. Crawford displayed charts showing the genetic markers that matched between the Starbucks cup and the material found under Caroline's fingernails. The probability statistics were overwhelming, the science unambiguous. Prescott's DNA was under Caroline's nails because she'd scratched him as he strangled her. There was no other reasonable explanation that the science would support. Carlton Wyatt, the defense attorney, argued that genetic genealogy evidence, while compelling, wasn't infallible, and that the circumstantial nature of much of the state's case left room for reasonable doubt. He suggested that DNA could have been transferred innocuously, that Prescott and Caroline might have shaken hands or had some other benign physical contact at the reception that evening. He challenged the reliability of 18-year-old security footage and questioned whether the truck in the video could be definitively identified as Prescott's. He argued that his client's standing in the community, his lack of any criminal history, his family obligations and civic contributions, all argued against the prosecution's theory that he could be capable of such a brutal crime. Judge Morrison, having heard both arguments, ruled that probable cause existed to bind Prescott over for trial, and that he would be held without bond pending that trial. The no-bond decision was significant, reflecting both the severity of the charges and the assessment that Prescott, with his substantial financial resources, posed a flight risk despite his deep roots in Savannah. As deputies led him out of the courtroom back to the detention center, members of his family wept openly. While members of the Whitmore family sat in solemn silence, their expressions suggesting that this legal victory, while significant, could never restore what had been taken from them. In the weeks following the preliminary hearing, the case generated intense public discussion about wealth, privilege, and justice in the South. Op-ed pieces appeared in newspapers across Georgia, debating whether someone of Prescott's social standing would receive a fair trial, or whether he'd benefit from advantages unavailable to defendants without his resources. Legal analysts discussed the strength of the genetic genealogy evidence, noting that while such evidence had been used successfully in several high-profile prosecutions, it remained relatively new and hadn't been tested extensively in Georgia courts. Civil liberties organizations raised concerns about privacy implications, questioning whether law enforcement's use of public genealogy databases violated Fourth Amendment protections against unreasonable search. District Attorney Patricia Simmons announced in September 2024 that her office would seek the death penalty against Prescott. This decision, while not surprising given the nature of the crime, intensified the already considerable media attention. Simmons explained her reasoning in a press conference. The murder was committed during the commission of another felony sexual assault, it involved torture or depravity of mind, and it demonstrated a disregard for human life that warranted the state's ultimate sanction. She noted that the Whitmore family supported this decision, though she emphasized that the DA's office made charging decisions based on law and evidence, not solely on victims' families' wishes. The death penalty announcement transformed the case's dynamics. Under Georgia law, capital cases require a death-qualified jury, meaning potential jurors who are categorically opposed to the death penalty can be dismissed during voir dire. This process tends to produce juries that are more prosecution-friendly, though defense attorneys argue it violates the principle of being judged by a true cross-section of the community. Additionally, capital cases automatically trigger heightened scrutiny of evidence and procedure, with appellate courts reviewing not just legal errors but also the proportionality of the sentence compared to similar cases. Carlton Wyatt filed a motion opposing the death penalty designation, arguing that the state's evidence, while sufficient for prosecution, contained too many inferential leaps to justify seeking execution. He pointed out that the sexual assault evidence was degraded by 18 years of storage, and the time the body spent in salt water, making definitive conclusions difficult. He argued that the depravity of mind standard was subjective, and that the prosecution was seeking death not because the evidence supported it, but because of the victim's prominent family and the political pressure surrounding the case. Judge Morrison denied the motion in October 2024, ruling that the death penalty determination was within the district attorney's prosecutorial discretion, and that the evidence, if believed by a jury, could support the aggravating factors required by Georgia law. The trial was scheduled for March 2025, giving both sides time to prepare for what would likely be a multi-week proceeding with national media coverage. As the defense and prosecution prepared their cases, investigators continued working. The GBI searched the Prescott mansion on Jones Street pursuant to a warrant, looking for the quilt or evidence of where it might have been stored. They found a cedar chest in the third-floor attic, containing numerous antique textiles including several 19th-century quilts, but none matching the specific pattern and fabric of the one found with Caroline's body. However, they did find photographs from a 2004 estate inventory, showing a quilt that matched the description, labeled as Confederate Memorial Quilt, circa 1870, Prescott family provenance. The quilt's current location was not documented in any subsequent inventory, suggesting it had been removed from the collection sometime between 2004 and 2006. Investigators also re-interviewed witnesses from the original 2006 investigation, asking specifically about Prescott's demeanor and interactions at the Jepson Center reception. Several people, their memories refreshed by looking at photographs and reading their original statements, recalled seeing Prescott speaking with Caroline multiple times that evening. One witness, a gallery donor named Helen Carmichael, said she'd noticed Prescott watching Caroline throughout the reception in a way that struck her as unusual, though she'd thought nothing of it at the time beyond noting it as mildly inappropriate for a married man. Another witness, a SCAD professor, recalled seeing Prescott and Caroline in what appeared to be an intense conversation near the gallery entrance around 9 p.m., though he couldn't hear what they were discussing, and had assumed it was related to the exhibition. This testimony suggested a connection between Prescott and Caroline that hadn't been apparent in 2006. Investigators dug deeper into their backgrounds, looking for prior interactions. What they found was limited but significant. Prescott's real estate firm had served on a committee in 2005 that provided funding recommendations for arts organizations seeking grants from the historic Savannah Foundation. Caroline, as a curator at the Jepson Center, had presented a proposal to that committee for funding to acquire a collection of 19th-century low-country landscapes. The proposal had been approved, and the acquisition had formed the core of the exhibition that opened the night she disappeared. This meant Prescott and Caroline had professional contact at least a year before her murder, contradicting his original statement to police that he knew her only casually as someone he'd seen at various cultural events. The prosecution theorized that Prescott had developed an obsession with Caroline during or after those committee meetings, that he'd engineered opportunities to interact with her under the guise of professional interest in the arts, and that on the night of April 14, 2006, something had triggered him to act on that obsession. Perhaps Caroline had rejected an advance, or threatened to report inappropriate behavior, or simply represented an object of desire he couldn't possess through legitimate means. The exact trigger might never be known, but the DNA evidence proved that whatever happened that night ended with Prescott strangling Caroline and disposing of her body in a way that suggested both planning and panic. The defense, meanwhile, pursued alternative theories and procedural challenges. Wyatt filed motions to suppress the DNA evidence obtained from the Starbucks cup, arguing that while trash pulls were generally legal, the targeted surveillance of Prescott constituted an unreasonable search that violated his Fourth Amendment rights. The motion argued that police had focused on Prescott, based on genetic genealogy, that was itself a warrantless search of his genetic relatives' privacy, creating a fruit of the poisonous tree problem. Judge Morrison denied this motion, ruling that Prescott had no reasonable expectation of privacy in items he'd voluntarily discarded in a public place, and that genetic genealogy using publicly available databases didn't constitute a search requiring a warrant. Wyatt also filed a motion to exclude testimony about the quilt's provenance, arguing that estate inventory photographs from 2004 didn't prove the Prescott family still possessed that specific quilt in 2006, much less that William Prescott had used it to wrap Caroline's body. The motion argued this was speculation piled on speculation, and that the quilt's existence in the Prescott collection years earlier was too attenuated from the crime to be probative. Judge Morrison reserved judgment on this motion, indicating she'd rule after hearing testimony about the chain of custody and the rarity of such quilts, which might make the connection more or less significant. As the trial date approached, Savannah itself became a character in the unfolding drama. Tour guides incorporated the case into their narratives, pointing out the Prescott mansion on Jones Street and the Jepson Center where Caroline was last seen. True crime podcasts devoted episodes to analyzing the evidence and speculating about what had happened that April night in 2006. The case became a lens through which to examine larger themes about Southern society, about how old families wielded power, about how wealth could shield people from scrutiny for years or decades, about how the facade of civility and culture could mask the darkest impulses. In January 2025, 3 months before the scheduled trial, the Prescott family made a decision that shocked many observers. Amelia Prescott filed for divorce, citing irreconcilable differences, and specifically requesting that all marital assets be divided immediately, rather than waiting for the outcome of the criminal case. The filing included an affidavit in which Amelia stated that she'd provided her husband with an alibi in 2006 because she'd believed him when he said he'd been home all evening, but that in light of the DNA evidence, she could no longer maintain that position. She stated that she'd been in bed asleep by 10 p.m. on April 14, 2006, and couldn't actually confirm her husband's whereabouts that night. This development was devastating for the defense. Wyatt had planned to call Amelia as a witness to corroborate Prescott's original alibi, but her affidavit effectively destroyed that strategy. Moreover, her decision to publicly separate herself from her husband sent a powerful message to potential jurors and the community at large. Even his own wife believed he was guilty. Legal analysts noted that Amelia's timing suggested she might have been approached by prosecutors about testifying for the state, and that her divorce filing was a way to avoid being compelled to testify against her spouse. As Georgia law provides a spousal privilege that allows one spouse to refuse to testify against the other. However, that privilege can be waived, and by filing for divorce, Amelia signaled she was severing the legal relationship that would have protected Prescott from her testimony. The divorce filing also revealed details about the Prescott family's finances and social standing. Court documents showed that William Prescott's net worth was approximately $8 million, most of it in real estate holdings and trust funds established by previous generations. The couple owned the Jones Street mansion outright, along with a beach house on Tybee Island and investment properties in Savannah's historic district. Their adult children, both in their 30s, had attended private schools and elite universities, moving in circles where family name and connections opened doors that merit alone might not. The divorce petition sought an equal division of assets and primary possession of the Jones Street mansion, effectively seeking to erase William Prescott from the family legacy he'd inherited. In February 2025, prosecutors made a strategic decision to offer a plea bargain, despite having announced they would seek the death penalty. District Attorney Simmons offered to reduce the charge from malice murder to felony murder, and to take the death penalty off the table in exchange for a guilty plea and a sentence of life without parole. This offer reflected a pragmatic calculation: trials are expensive, outcomes uncertain, and capital cases particularly vulnerable to appellate reversal. A guaranteed life sentence achieved the primary goal of ensuring Prescott would never be free again, while avoiding the years or decades of appeals that death penalty cases inevitably generate. Carlton Wyatt presented the offer to Prescott during a meeting at the Chatham County Detention Center. According to later court filings, Prescott rejected it, maintaining his innocence and insisting on his right to trial. Wyatt advised him that the evidence against him was substantial, that genetic genealogy had proven compelling in other cases, and that a Chatham County jury was unlikely to be sympathetic to someone from his privileged background. But Prescott remained adamant. He would not plead guilty to a crime he insisted he didn't commit, regardless of what the science appeared to show. This decision meant the case would proceed to trial, scheduled to begin on March 17, 2025. Jury selection was expected to take at least a week, given the death penalty designation and the extensive pre-trial publicity. Judge Morrison ordered an expanded jury pool of 300 potential jurors, drawn from across Chatham County, to ensure enough candidates survived the elimination process. She also imposed a gag order on both sides, prohibiting attorneys from making public statements about the evidence or their trial strategies, an attempt to protect Prescott's right to a fair trial despite the intense media interest. The Whitmore family prepared for trial with mixed emotions. Richard Whitmore's health had continued to decline, and there were concerns he might not live to see the verdict. Margaret Whitmore told friends she felt both vindicated that someone was finally being held accountable and exhausted by the prospect of reliving Caroline's death in graphic detail during weeks of testimony. Caroline's sisters struggled with the publicity, with having their family tragedy dissected in newspapers and on television, with seeing their sister reduced to evidence exhibits and crime scene photographs. As March approached, Savannah braced for an event that would force the city to confront uncomfortable truths about itself. The trial would be more than a criminal proceeding. It would be an examination of how power operated in the South, how old families protected their own, how privilege could delay but not ultimately prevent justice. The Spanish moss would continue to drape from the live oaks on Jones Street. Tourists would continue to photograph the elegant townhouses and walk the cobblestone streets, but underneath that picturesque surface, something fundamental had shifted. The case of Caroline Ashford Whitmore had exposed what many had long suspected, but rarely discussed openly, that Savannah's beauty, its history, its carefully maintained traditions were not just celebrations of a storied past, but also mechanisms for concealing uncomfortable realities. The Confederate flag quilt that had wrapped Caroline's body was a perfect metaphor for this duality. An heirloom that some viewed as historical artifact, and others recognized as a symbol of oppression, carefully preserved by families who saw themselves as guardians of heritage, but who were, in some cases, also guardians of terrible secrets. The trial promised to be a spectacle, with national media coverage, with expert witnesses debating the reliability of genetic genealogy, with testimony that would detail not just a murder but an entire social system that had for 18 years allowed a killer to live freely among the very people whose trust he'd violated. Whether the jury would convict, whether Prescott would ultimately face execution, whether justice delayed for nearly 2 decades could still be meaningful, these questions would be answered in the months ahead. But one truth was already evident to everyone watching: the arrest of William Habersham Prescott IV had accomplished something beyond advancing a criminal case. It had shattered the illusion that in Savannah, as in so many places where wealth and lineage confer power, that certain people were untouchable, that certain families were above scrutiny, that the past could be carefully curated to exclude the ugly parts. Caroline Whitmore's murder had been a tragedy in 2006. The 18 years of silence that followed had been an injustice. But the reckoning that was finally coming, imperfect and incomplete as all human justice must be, represented something profound: the understanding that no amount of moss-draped beauty, no length of family lineage, no accumulation of social capital, could ultimately excuse or conceal the taking of an innocent life. Savannah would remain beautiful. The azaleas would continue to bloom each spring in Forsyth Park. The mansions on Jones Street would continue to command multi-million-dollar prices. Ghost tours would continue to thrill tourists with tales of Civil War-era hauntings. But the city would also have to integrate this new ghost into its collective memory, not a romantic specter from the past, but a recent crime, a modern evil, a reminder that the worst horrors are often committed, not by strangers in the night but by neighbors, by people whose names everyone knew, by men who wore nice suits, and served on boards and appeared in all ways to be pillars of the community. The trial of William Habersham Prescott IV would begin in 17 days, in courtrooms and in the court of public opinion, in newspaper columns and podcast episodes, in conversations at the Old Pink House and in living rooms across Chatham County. People would debate the evidence, the science, the question of guilt, but for Caroline's family, for the investigators who'd worked the case for 18 years, for the forensic genealogist who'd finally provided the key that unlocked the mystery, the trial was almost beside the point. The real victory had come the morning that GBI agents knocked on the door of that Jones Street mansion and placed handcuffs on a man who'd thought himself untouchable. Justice delayed is not justice denied, the old saying goes. But justice delayed causes its own particular form of suffering, extending the trauma, allowing the guilty to live freely while the innocent are mourned, creating a wound in the social fabric that doesn't heal but rather festers. Savannah had lived with that festering wound for 18 years. Now finally, painfully with all the complexity that truth brings, the city would have to confront what it had allowed to happen, what it had failed to see, what its commitment to discretion, and propriety, and protecting its own had cost. The Spanish moss would continue to sway in the breeze, filtering the sunlight that fell on Savannah's historic squares. But anyone walking those squares now would know what that beauty had hidden. And perhaps that knowledge, uncomfortable as it was, represented its own form of justice, the kind that comes not from courtroom verdicts, but from collective recognition that nowhere, no matter how lovely, no matter how steeped in tradition, is immune to the darkness that humans are capable of inflicting on one another. Caroline Whitmore deserved better than to have her murder become another ghost story, another macabre attraction in a city full of them. She deserved to be remembered as she was, a young woman who loved art and history, who had her whole life ahead of her, who was taken violently by someone she had no reason to fear. And now, finally, she might also be remembered as the woman whose case helped end an era of impunity for Savannah's elite, the woman whose death, though it couldn't be undone, could at least serve as a catalyst for accountability in a place where accountability had too long been a luxury afforded only to those without powerful last names.